Hello, welcome again to Evidence. Now we are through with the presentation of witnesses and authentication and proof of documents under Rule 132. Now, let us proceed to the last part, the offer and objection. So by the way, this offer and objection is not much, or the provisions here does not much apply to us criminologists. Okay, so it's more of, or the application of the provisions here under offer and objection is more of use to the prosecutor or the defense counsel or the defense lawyer, okay, or in general the lawyers who are handling the case. Okay, it's not more of the investigator or the criminologist, because the investigator or criminologist act merely as witnesses for example, the prosecution. Okay, so yung prosecutor talaga ang, ang medyo dapat mas nakakaalam kung paano gamitin tong provisions under this offer and objection. Okay, so let's proceed to section 34, offer of evidence. The court shall consider no evidence which has not been formally offered. The purpose for which the evidence is offered must be specified. Okay, so this offer of evidence is the second, the second part of or the second part of the process before the evidence is admitted by the court. Okay, so ang sabi sa section 34 is that if hindi na offer ang evidence, hindi siya pwede or hindi siya i-consider ng court in deciding the case. Okay? So dapat aside from the presentation of the evidence, okay, dapat i-offer siya. Okay, so hindi automatic na kung i-present mo ang evidence sa court, hindi automatic na admissible yan. Dapat i-offer mo pa siya. Okay, and after offering that evidence, doon na yan i-admit ng court if admissible siya or competent siya. So again, the purpose for which the evidence is offered must be specified. So dapat daw i-specify yung purpose ng evidence, kasi if the purpose for which the evidence is being presented or offered was not specified during the formal offer of the evidence, then the evidence will not be considered for that purpose, okay, that you want. Okay, so under, or as ruled by the Supreme Court in Spouses Ragudo versus Fabella Estate Tenants 466 CRA 136, the court shall consider the evidence solely for the purpose for which it is offered, not for any other purpose. Kung ano yung purpose ng evidence na specify during the formal offer, yun lang yung purpose na i-consider ng court, or in that sense only will the court consider the evidence, not for other purpose not specified during the formal offer. Okay? So when to make the offer under section 35, all evidence must be offered orally. So this paragraph 1 is telling us how to offer the evidence. So it must be made through speaking. okay, orally, not written, okay, not through text or something. It must be offered orally. Okay, so the offer of testimony of a witness in evidence must be made at the time the witness is called to testify. Okay, so before examining the witness, there must be an offer made of the testimony of the witness. Okay, kasi ang nangyayari dyan, the court will instruct for example, the prosecutor to call in his witness. Okay, and then the prosecutor will call the witness. For example, sabihin ng prosecutor, Your Honor, I am calling to the witness stand witness or Mr. Juan de la Cruz. Okay, so Juan de la Cruz will now go to the witness stand, and then Juan de la Cruz will now be made under oath. Okay, so the witness will now be asked if or will now make an oath to tell the truth and nothing but the truth. Okay, so ganyan. And then after that, after swearing the witness, that is the time when the prosecutor will now offer the testimony of the witness. Okay, so sabihin ng prosecutor na, Your Honor, the prosecution is offering the testimony of the witness Juan de la Cruz for the following purpose, or to prove that blah blah blah. Okay, to prove that the accused murdered the victim, ganyan, or the accused robbed the house of the victim. So ganyan, offer of the testimony, offer niya, and then nag-specify siya ng kanyang purpose for the testimony of the witness. Okay, so that's how you offer. And then after that after offering, the prosecution will now proceed to examine the prosecutor will now proceed to examine the witness. So mag-question na yung prosecutor. So ganyan mag-offer ng testimony of a witness. Now for documentary and object evidence naman, the offer shall be made after the presentation of a party's testimonial evidence. So kung matapos na lahat ng mga witnesses, examination ng witnesses, doon na mag-offer ng documentary and object evidence. Okay, so isa-isahin yan ng prosecutor. So parang ganito, after the examination of witness, the prosecutor will now say, Your Honor, we are offering the knife used to the killing of the victim as marked as Exhibit A, ganon, for the purpose of proving that such murder weapon or such knife was used to kill the victim. So ganon, offer niya yung knife, then state the purpose of the evidence. But it is made, okay, remember, it is made after the presentation of the party's testimonial evidence. Okay, so if we have an offer, of course, we also have an objection. Okay, so the objection, it is provided here in Section 36. Objection to offer of evidence must be made orally immediately after the offer is made. So that is a general rule on when to make an objection. Okay, according to the first paragraph of Section 36, it must be made immediately after the offer is made. If you think or you realize that the evidence being offered is not admissible, so go back na naman, gamitin nyo yung Rule 130, di ba? Sa rules of admissibility natin. So if you think that the evidence being offered is not admissible, for example, because the documentary evidence is not the original, okay, is not the original, then you can object. Okay, you can make the objection to the documentary evidence being offered being um, for being prohibited under the original document rule, right? Okay, so that is when to make, as a general rule, the objection must be made immediately after the offer is made. Objection to the testimony of a witness for lack of formal offer must be made as soon as the witness begins to testify. So if the prosecutor or the defense lawyer forgets to formally offer the the testimony of the witness, then an objection must be made that no formal offer was made for the testimony of the witness. Okay, so objection to a question propounded in the course of the oral examination of a witness must be made as soon as the grounds therefore become reasonably apparent. Okay, so pwede rin mag-object question on the questions made by the examining lawyer or the examining prosecutor. Okay, if you realize that the questions being propounded will call for an answer which is not admissible, because for example the answer will be hearsay, if you think that the answer to the question being propounded will be a hearsay statement, then you can make the objection. Okay, remember the question before, it is saying here impliedly under the second paragraph of this section, it is impliedly saying that the objection must be made before the immediately after the question is propounded, and it is seen, or it becomes apparent, that the question calls for an answer that is not admissible. Okay, so it must be made before the answer, meaning the objection must be made before the answer is given by the witness. Okay, so the grounds for the objection must be specified. Okay, so the grounds, specify mo, siyempre kung mag-object ka, dapat i-specify mo kung ano yung ground ng iyong objection. Hindi pwede na, objection, Your Honor. Ganun ka lang, tapos ma-confuse yung court or yung judge kung ano ba yung, bakit ka nag-object? Ano ba ang rason mo, bakit ka nag-object? So, if you will not specify your ground for the objection, then the objection shall necessarily be overruled. Hindi siya mag-grant. And the otherwise inadmissible evidence will become admissible. Okay, so it's important to take note that if the objection is not made when the objectionable evidence is apparent and the objection is not made, then the objection is deemed waived. Okay, so dapat talaga mag-object, kasi kahit na incompetent or inadmissible ang evidence, but if you do not make the objection, then the otherwise inadmissible evidence becomes admissible. Okay, pwede siya i-admit ng court. Okay, so that is why it is really important to make the objection. Okay, so section 37, when repetition of the objection unnecessary. When it becomes reasonably apparent in the course of the examination of a witness that the questions being propounded are of the same class as those to which objection has been made, whether such objection was sustained or overruled, it shall not be necessary to repeat the objection, it being sufficient for the adverse party to record his or her continuing objection to such class of questions. So hindi na daw under section 37, hindi na daw kailangan i-repeat yung mga objections mo before. Okay, so if the same yung objection mo to the other question being propounded by the opposing counsel, then it is not necessary to repeat the objection. But okay, provided that you have made it to record, okay, into record that you will be objecting to the same kind of question or the same class of questions. Okay, so for example, here say yung question niya is in the direct examination, yung question ng opposing lawyer is leading. Okay, sa direct examination kasi siya, diba, remember, a leading question is not allowed during the direct examination. Now, if during the direct examination, the question is leading, you can object to it. And then you can say to the court that you will object to the same class of questions if the opposing party still makes a leading question during the direct examination. Okay, so in that way, hindi mo na kailangan ulit-ulitin pa yung objection mo. So that is section 37. Let's proceed to section 38. Ruling. Okay, the ruling of the court must be given immediately after the objection is made, unless the court desires to take a reasonable time to inform itself on the question presented. But the ruling shall always be made during trial and at such time as will give the party against whom it is made an opportunity to meet the situation presented by the ruling. So, the general rule here is that yung judge must give its ruling to the objection made, whether to overrule or to sustain the objection. Okay, by the way, if we say overrule, the objection is overruled, it means that the judge do not agree with the objection. Okay, so tama yung admissible yung evidence. It means na the judge is of the opinion that the question being propounded is proper or the evidence being offered is admissible. So overruled yung objection. Now if we say sustain, the objection is sustained, it means that the judge agrees with the objection. So the question will not be allowed or the evidence will not be admitted. Okay, so according to section 38, the judge or the court must immediately give a ruling to the objection made. However, if there would be cases really that the objection or the issue surrounding the objection is difficult. Okay, hindi agad mare-resolve ng judge yung objection. Mahirap i-resolve. So in that case, the judge may take a reasonable time to inform itself whether to overrule or to sustain the objection. So mag-study siya ng konti kung ano ba dapat ang gawin sa objection. But the objection daw, according to section 38, the ruling to the objection rather must be made during the trial. So that in that case, the the party who made the objection, or the party against whom the objection was granted or sustained, can prepare, okay, can prepare to the situation presented or to the consequences of the ruling. So that is section 38. Now the reason for sustaining, this is the second paragraph ha, the reason for sustaining or overruling an objection need not be stated. However, if the objection is based on two or more grounds, a ruling sustaining the objection on one or some of them must specify the ground or grounds relied upon. Okay, so it is just saying that the judge is not obligated or has no obligation to say the ground for overruling or sustaining the objection. O, hindi na kailangan i-explain ng judge kung bakit niya sinustain or in-overrule ang objection. But it is saying here that if there are, for example, two grounds raised or two reasons for the objection, okay, if nag-object yung lawyer to the opposing party's evidence and dalawa yung ground na rinaise niya for the objection, then the judge must specify, okay, if yung isa lang yung sinustain na objection and yung isa is in-overrule, the judge must specify kung saan yung ground na sinustain niya at saan yung ground na in-overrule niya. Okay? Section 39, striking out of an answer. Should a witness answer the question before the adverse party had opportunity to voice its objection to the same, or where a question is not objectionable but the answer is not responsive, or where a witness testifies without a question being posed or testifies beyond limits set by the court, or when the witness does a narration instead of answering the question and such objection is found to be meritorious, the court shall sustain the objection and order such answer, testimony, or narration be stricken off the record. Kasi nga, di ba, as we have discussed, in objecting a question, the objection must be made before the answer is given. So that is the general rule. Dapat daw mag-object ka before the witness answers the question. Okay, however, there are section 39 gives us the exceptions to the general rule, in which the objection can be made even after the witness has already made or has answered the objectionable question. Okay? So it's provided here. So let's dissect section 39. Ano ba yung mga instances kung saan pwede kung maka-answer na yung witness and dun pa na raise yung objection, pwede i-strike yung answer ng witness. If we say strike, tanggalin siya sa record, i-erase siya from the record. Okay, so ano ba yung mga situations na yon? So first is a witness answers the question before the adverse party had the opportunity to voice fully its objection to the same. Okay, so parang this situation contemplates a situation where the witness immediately answers the question and parang naunahan niya yung objection ng opposing lawyer. Okay, naunahan niya yung objection ng opposing lawyer. Naka-answer na siya and before the opposing lawyer raised his or her objection to the question. Okay, so in that case, if the objection is reasonable or is proper, then the answer of the witness can be stricken off from the record. Another situation is where a question is not objectionable but the answer is not responsive. Okay, so in this case, of course, the opposing party or the opposing lawyer cannot object to the question because the question is not objectionable. However, the answer of the witness is not responsive to the question being propounded to him or her. So in that case, even if the objection is only made after the answer was given, because the question was not objectionable, then the answer can be stricken off the record for not being responsive. Another situation is where a witness testifies without a question being posed or testifies beyond the limits set by the court. So of course, the opposing counsel cannot make his or her objection because there is no question being propounded. And kahit walang question, nagsalita yung or nag-answer yung witness, nag-testify siya kahit walang question. So in that case, it can be objected to and the testimony can be stricken off from the record. Another is when the witness does a narration instead of answering the question. So nag-narrate na siya ng kanyang testimony. Mataas yung testimony niya kasi ang rule kasi dyan, during questioning, there must be a question and then the answer must be responsive to that question. And then, hindi pwedeng magsalita yung witness sa hindi tinatanong sa kanya. Okay, so hindi siya pwedeng mag-narrate ng kanyang facts. Ano ba yung mga nakita niya, kung ano ba yung mga nakita niya, and then kahit walang question, nag-testify na siya. Okay, malayo na yung inabot niya sa kanyang mga narration. So in that case, it can be objected to and be stricken off from the record. Okay, so that is section 39. Section 40, the last section, tender of excluded evidence. If documents or things offered in evidence are excluded by the court, the offeror may have the same attached to or made part of the record. If the evidence excluded is oral, the offeror may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. So if yung evidence or yung objection is na-sustained, of course, excluded na yung evidence. So, however, even if it is excluded, the party presenting that excluded evidence may attach the same to the record and made part of the record. Okay, so that is section 40. So that ends Rule 132, the presentation of evidence. So the next topic will now be Rule 133 on the weight and sufficiency of evidence. So that ends our video discussion for this session.